My lord, kindly
Done
take,
from
my lord,
end.
only, my lord, kindly see my submission, my lord, for the college
Everything has been
authority.
done from my end.
From the college authority, my lord, kindly
Are
see
you
my.
not realizing what I am saying?
Yes, my lord, I am.
Not realizing.
My lord, till now, my lord, judgment was not delivered, my lord. Only
What are the preparatory action before the judgment is delivered? What are the preparatory action?
the preparatory action, my
What
lord,
is the
I have
preparatory
done by your lordships, my lord, that I am admitting, my lord. But, my lord,
Everything done.
my lord, due to my illness, my lord, I could not come today, till today, my lord.
পুরো dictate করে দিয়েছি।
My lord, only, my lord, kindly see, and after that, my lord, only kindly see, my lord. My lord, I know, my lord, your lordships here and concluded, my lord, after that, my lord, till today, my lord, tomorrow, my lord, I was ill and I could not come, my lord, today I have come, my lord, from 29th.
লিখে দাও, জানি না।
হ্যাঁ সব লিখে দিয়েছি
এটা দিয়ে দাও।
একটু দিয়ে দিন দেখো
Yes.
My lord,
my lord.
may I be permitted to mention a matter with some hesitation, my lord? My lord, 3 appeals which have been heard, my lord. The RERA matters which I had argued before your lordship, matter before the lower court is coming up on Monday.
Tomorrow.
Otherwise, I would have prayed for a stay and your lordship injunct me. I'm grateful, my lord. I'm grateful.
May I have ballots kindly, my lord, to mention item number 7 and 8, my lord, which are appearing as specially fixed matter. My lord, I was enjoying an interim order in the fixed matters, my lord, item number 7 and 8, my lord, in my lord's today's list also. My lord, the interim order expired on 31st January. My lord, you could not, my lord, mention. My lord, may it appear, my lord, as for, my lord.
7 and 8 is fairly at the top.
My lord, we have served notice and my lord, we are mentioning on notice.
It will be called.
May be permitted to mention, your lordship, for inclusion of one FA matter of 2013.
Substantially heard by another my lord, honorable coordinate bench. My lord, they have concluded their submission there, then my lord, determination got changed. Yes.
To be mentioned দিয়ে দাও।
Great.
May I be permitted to mention one matter? Our fault,
Hold your breath for the time. Yes.
Your lordship, may I be permitted to mention this matter for restoration? Yes, your lordship.
This matter appeared, this batch of matters appeared on 29 January. My lord was pleased to make it out of list. These matters are all matters, my lord had considered this aspect. Consent matters, my lord was pleased to dismiss the appeal. My lord, my fault, my personal fault. My lord, no, my lord, I do not, it was our fault.
To members of the bar.
It was our fault. My lord, I'm not saying.
Anybody.
I should have been, my lord, it's my fault. My lord, I am taking the responsibility. My lord, I was,
The fault on our
my lord, I was only playing any day, my lord, subject to,
We are not at fault, then what to do?
my lord, any day, my lord.
And the other matters are also.
My lord, it can be disposed of to be mentioned because my lord was pleased to hold that this consent matters we have to go before the single bench. My lord, the same order would be passed. Same order, my lord, same order. Was I'm grateful, my lord.
Out of list হয়েছে।
Item number 1.
For the appeal, lordship, this is assigned matter, lordship.
Why it is assigned to the.
Past provision matter has been released, lordship. This is the first time assigned matter before your lordship.
Why it has been assigned?
It's a review application passed by your lordship order and
What is this review application?
lordship. As per your lordship and Honorable Justice Rabindranath Samant lordship.
I understand, I have seen that.
Lordship.
This matter has been assigned to this bench by the Honorable Chief Justice. You are for
Appeal and lordship.
the council and review application. The council appearing for the review applicant submits that the matter may be listed any day, subject to the convenience of the bench. There is no appearance on behalf of the respondents. Let this matter be listed next week under the heading review application. So the counsel for the advocate and record of the applicant is directed to communicate this order to the counsel who appeared for the respondent in the review application.
Matter number 2.
What is this? Top, it is written top as first matter. Order, this was. Where is Mr. Damayanti, Miss Damayanti Nandi Kundu? Anybody know? Anybody knows him? Her? Ipobu kesche?
Yes.
Can 7 টা কি হচ্ছে? Can 7 is a restoration. This is for default. So for default হয়ে পড়ে আছে 7th October 2020. Restoration ও করতে আসছে না। Just pass over করো না হলে yes. Call.
Application. Item number 82.
এখানে application তো 13 থেকে আছে। আচ্ছা 82 পর্যন্ত গেছি। ঠিক আছে। What is this FME
My lords had been hearing this matter.
hearing?
Yes, on the last year occasion when my lord
What
sat.
is this application? Can one?
But, my learned friend has pointed out that 6 of the pages of his brief are illegible.
What? Achha.
I've checked up my lord's brief. They are not as bad. Could have been better, but they are legible.
So you have given them a legible copy.
No, no,
8 pages are not.
Copy served 3 months ago. He's pointing this out today here. But he is right. Those are orders of board and other.
Just
One night.
why you have been transferred to another school where you have joined.
My lords had put this to me.
I think you are a whistleblower.
No. I was
Blown
a
the
school
whistle.
teacher. I was a school teacher there. My lords had
I understand that
very
there was
pertinently pointed out why are you still chasing this private respondent?
This is a response. They have already initiated a proceeding.
Even after the-
Cause has been issued, reply is given. Now they will take care of that.
One thing, my lord, the answer to the query why I am still after him. But that was the question, my lord, on which we had ended the last hearing. My lord will kindly seize, my lord, my pleading at page 27, paragraph.
Let me see your prayer in the writ petition. To forward a detailed report of inquiry conducted, that is already done.
That is hardly a detailed report. It does
Whatever-
not say.
Whatever, sir, the detailed report, cryptic report, concise report, it is immaterial that you have.
The report is that we are
Sorry.
issuing a show cause and he'll reply to that.
So what can be done? What more?
The
Detailed report, that what we will take a decision, that should also be
The
reflected in
first-
report.
kindly see.
We're not talking about the detailed report.
First order of the board directing,
Sorry.
my lord, proceedings
Then directing to initiate a disciplinary proceeding, they have already initiated.
that they were supposed to do it in 2022.
If there is a delay, that will take care of that. They have already initiated. The report says the show cause notice given, reply has been received. Now they have to proceed. What is the difficulty?
Kindly seize, my lord,
Request that
how
expedite.
I am prejudiced,
Expedite.
how I am
Without
He has
violating any of the provision of national justice or the concept of national justice. That should be there. But they have to proceed.
my lord,
They expedite.
my kindly see, my
As far
one
the
thing.
instruction of the state is concerned, her that her grievance has already been
No,
redressed, I think.
My
That
service book is
now-
still there.
Now
And
he is aggrieved
You
by
transfer
that.
the service book.
And the poor
From the
teacher in
DI.
charge, she has expressed,
DI is in report, nothing is pending for her.
my kindly seize page
She is
180.
aggrieved that against the headmaster. Proceeding is
There is no prayer challenging that particular order of transfer or a decision.
No, it was at my instance.
now she is now aggrieved against the
It was,
headmaster.
but she is a,
How she's prejudiced?
চুপ করে বসে থাকো।
kindly seize page 180.
Client has-
There was a
Client is
direction, there was a direction.
Client is here. Your client.
No, she does. But unlike my learned friend's client who is present every day,
No, that live streaming is going on.
hardly. Well, she is not that savvy either. But page 180, there was a direction that the teacher in charge, who has now been appointed in place of the headmaster, she completes my service book. But
You have come up with certain reliefs. It appears that those reliefs have been taken care of. Literally, the single bench has said that those have been granted to you.
which means for the service book, I have to file another writ petition.
The difficulty is only, kindly please consider, the court has granted the relief which you prayed for. Now you are still aggrieved because you are trying to reopen certain issues which were not there in the writ petition, which were never a part of any cause of action. Nothing of that
It was a
kind.
developing thing.
Sir, the service book, you sought that there should be a disciplinary proceeding initiated against the respondent number 7, which in fact the report reveals that has been taken care of. That was your primary grievance. That is
I
your
did
primary
not-
relief that has been granted by the.
I did not anticipate that the teacher in charge, the replacement, will find so much difficulty in not finishing my service book, maybe rightly.
The service, whatever.
Now I am unable to get my salary in the new school.
Now this was never the subject matter of the writ petition.
This is pending this appeal. This is
Thing means any issue, suppose during the course of argument, something cropped up unconnected with the cause of action, you will say now you include it.
my kindly sees it's very much a part of the kindly sees page
Where is your grievance? Relief. I am reading the reliefs which you have claimed. What is the relief?
the
you have
relief
claimed?
was not paid for because
Sorry. First relief is the mandamus directing the respondent commissioner of the school education, being the respondent number 2, to forward a detailed report of inquiry conducted by the officers appointed by him by an order dated such and such to the respondent board within a stipulated time to be fixed by the High Court. Will the High Court say that within that time they have initiated a proceeding? Report
they initiated the proceeding in
whatever,
2022.
the report has come. The report has come.
The report is the last annexure.
I
Kindly
do
see
not
the
know
report.
whether it is a detail, it is a concise, it is a cryptic, it is up to them what they will do. Report has come. Second prayer is to initiate a disciplinary proceeding against the respondent headmaster, that is the respondent number 7, on the basis of the order dated such and such, which they have done, issued a show cause notice, two memos have been issued by two authorities. The reply is also given by that headmaster.
That is the preliminary show
Now-
cause, not the
now,
formal charge sheet.
whatever. So you can't say that the court cannot control the entire disciplinary proceeding. It is an administrative action of the authority. They have to follow the principle of natural justice.
They did nothing
They
for
have-
2 years.
That is what you come with the prayer that they have violated. What principle? You should be heard. You should be cited as a witness. It is up to them. Prosecution. You have filed a complaint. You will be taken care of.
Well, kindly, one thing, kindly see page
Everything.
180. Page
And
180.
salary. This is not anywhere the relief nor a cause of action.
The learned
of this
single
kind.
judge had taken care of that.
You
by-
ought to have amended the prayer when you volunteers that you
That
will
would be a
transferred.
fresh cause of action. My service
Definitely,
book.
you
But-
can be because of the subsequent event. You can bring by way of an amendment, which you chose not to. In the appeal, for the first time, you are raising this question.
Because
Is it
the
permissible?
because the order took care of that. That the service book, page 180. Page 180.
Sir,
Kindly
order
see
is-
page
order is
180.
before us. That's all.
Kindly see the order at page 180.
Sir, I have seen the impugned order.
There was already an order that the teacher in charge will complete the service book.
Please,
page
please.
Page 180. There's a separate order.
Which order of the court?
Page 180. That order is at page 180.
You are not challenging that
No,
order.
I accepted that. But that the
That is-
teacher in charge.
We are concerned with the final order.
This is
Final
a
order is of 20th of August.
this is in a
2020.
separate proceeding, but the teacher in charge is now finding it impossible to.
Mr. Chatterjee, you are a veteran in the profession, sir. Please consider. There is no pleading. There is no pleading
This
in
was
this
an-
regard. Please.
There's a
There is
pleading at
no-
page
please, that
page
salary has
27.
been stopped. Nothing. There is no relief you have claimed in the writ petition.
No relief because there's already an order.
Secondly, order. And without any amendment having been brought, without any.
There's an order in a separate writ petition. Now the
order
content,
beholds-
another
beholds
writ
the pleading.
petition, all that.
And that was an interim order, and merged with the final order, nothing has been said.
That was in a separate writ petition. Separate writ
Then
petition.
go before that separate writ petition. Why you are bringing it here in this?
Because I was trying to answer my lord's query. What is troubling you now? That is the answer
That
to
will
the
trouble
query.
you more.
Unless I get my service book, I'll be troubled till my retirement.
For that, there is a separate writ petition. The orders have been passed in a separate writ petition. How can you bring it in this writ petition?
Of course, there's an order.
When I am representing the school and he has not made any such application before the school, neither any writ petition is pending.
Well, a charge sheet issued, already inquiry officer appointed, inquiries have submitted a report, we have received on 10th January. Now board will issue the final order, what?
Yes, sir.
Yes,
What more?
nothing is left.
How
I-
she is prejudiced?
I want to, my lord, I want to find out. I want to find out whether the board has taken care of, my lord, included within the.
How she is?
Rule does not provide such.
Okay,
How can a writ of such nature lies? A disciplinary proceeding, I can understand you have raised serious issues. The authorities who are in the helm of the affairs were not taking any steps. I can understand to some extent that a litigant may have demands that, look, I have raised such a serious issues, board is not doing it. If the board has already initiated,
In a criminal
can't
trial, also the
control
de facto
from
complainant
outside,
has
you will
certain rights.
control that you will say this in the as a witness in the deposition.
Yeah.
You will say this in the deposition that you can't control.
That I can't control, I know. But my lord's
You are-
query
you
was,
are
how are you
everything.
troubled?
Every bit of the steps must be there. They will communicate to you. Today, he appeared, he has said all these things, I have recorded. Everything will be made known.
That would be ideally, that should be done.
That would be ideally. You will be cited as a witness. Ideally.
The honorable judge had held that there's a collision between the DI and the
This is absolutely.
Third, now the higher authority have taken steps.
higher authority slept over it,
No.
was saddled with a cost of 1 crore.
Buyer, you can come as a buyer.
The higher authority slept over it and
It is
So
not
they have
submitted for
activated the
that.
process.
I have already.
They have activated
they have, after being saddled with 1 crore.
Say anything more on that? You complete your, exhaust your turn, we'll see this.
Then all I am seeking that so far as the service book is concerned, that will be a different cause of action. I'll pursue it.
Then why you are filing an appeal?
Appeal.
You have filed an appeal. against this order, which takes
No.
care of all your.
The basic issue was whether I lose my locus on transfer.
Sorry.
If my lords decide against me, my lords decide.
Yeah, it's not a subject matter here.
Yes, that is what the learned judge.
Disciplinary proceeding to be initiated, everything to be done. There is nothing with regard to transfer.
The honorable judge has held that because of my transfer,
The order which is dehors the pleading. What do you think? The order? Is it binding? And that was at the interim stage, now it has merged.
that is not a separate proceeding.
Then you can't bring it here.
That was my attempt to satisfy my lords that
Let us see.
I am still troubled.
A belligerent litigant who
Why belligerent,
was
my lord?
successful in the before the single bench.
For the writ petitioner, my lord, respondent number 1.
Impugned order at page 56. Starts from
I always read the memorandum of appeal where the interim order or order is annexed. Just give us 30 seconds time to query.
Yes, sir.
3-page order.
School authority.
Wonderful. I wanted the school authority to come in this regard.
I also, my lord, after going through some interpretation is required to be.
Nothing.
Yes.
Nothing. Oh, sorry, we should not say.
Let
You
me.
exhaust your energy, then we will do what
Now,
we have to do.
my lord, I oblige to your lordship. Paragraph 9 of my application. At the time of
What is your application? You are not a school. You are no application. The teacher has filed. The teacher has filed application. What your application? Why you say?
In my application, appropriate order.
Say the stay application.
Stay application.
Say that.
Yes, of my stay application,
Yes,
school stay
say that.
application. Paragraph 9, internal page 10.
What?
At the time of making the application by the concerned teacher, but no medical documents we did not
Ought
get.
to have intimated it.
Yes. Now,
Forwarded. Please. If there are no medical documents, you could have said that I am forwarding because there is no supporting documents there.
no.
And if there is, the interpretation is silence, there is nothing. It says on a medical ground, if anybody wants, a medical board is to be constituted by the DI. He will undergo, and if the medical board prescribes that yes, these are the sufferance, the authority.
No,
will
it is
decide.
to be.
Who are you to decide?
It is to be. That is my contention before you.
Who are you to decide?
That is why when I am submitting that medical documents, it is to be first scrutinized by our medical
Where is the provision?
managing committee.
Where is the provision for scrutiny by the managing committee?
Yes.
Where is the provision?
That the rules is said.
Please
Yes.
show us the rule. Where is the provision?
Let
have
me
not
place
read it.
two facts. And 12 teachers, please.
Yes,
please,
my lord,
please,
there
please,
are
please.
provisions.
What
আমি
provision?
বলে দিচ্ছি, দাঁড়া।
What provision?
Now I'm coming to the rules itself. Now, facts to be decided.
Nothing.
Now
The facts are very clear. Application is uploaded on the USORC portal seeking a transfer on a medical ground
medical ground.
without accompanying any medical document.
Grateful.
Then what is supposed to be done by the school authority and what is supposed to be done by the other authority?
Now,
Let us see.
now
show us the
total,
rule.
yes, total,
Show us the rule.
yes, my lord, total student,
Not necessary.
not
You show us
necessary.
the-
I'm just 1 minute. Total student almost 800s. Teacher 12. Now ratios 1:66.
3rd January notification.
No, I know
is
this.
known to me.
Now,
Yes.
straight away coming to the rule.
Yes.
What to
Straight
be
away,
done?
That's why
What to be done? Now kindly take the rule itself. What is our duty to first?
What is this? Tell me. We have a compilation.
Yes, my lord,
Tell us. No. Don't give.
immediately after
We have a compilation.
yes, my lord, I'm grateful to your my lord.
Which one?
Immediately,
Give me the date.
yes, that the 707 notification itself.
We don't have 7 zeros. You just give us
Amendment 8 September
8 September
2021.
2021.
That amendment.
That is an amendment.
Yes, my lord.
Page 15. Yes. Yes, ground of
Now
transfer.
ground 6.
Ground of transfer.
procedure for submission of consideration of the application.
Sir, first ground of transfer, Rule 4 is also amended.
Grateful. Yes.
Read that first.
Yes. Yes. Rule 4.
Just previous page.
My lord.
Previous. At the bottom.
Grounds for transfer.
Yes.
An incumbent may apply online in the designated post portal for transfer of a following grounds. Any incumbent, his or her son, daughters of the spouse suffering from malignant diseases, several heart diseases, renal failure, thalassemia, replacement of organ, serious gynecological disorder. Here, gynecological disorder admitted.
Then,
Causing serious problem attending the school. Now, I am coming to 6.
Correct.
Procedure. Straight away, my lord, kindly come to 2E.
please read the main.
2E. May I am reading the 2E?
An incumbent may apply for transfer on grounds and the manner provided in Rule 4.
4.
So, Rule 4 is there.
Yeah.
The respective authorities involved in the process of transfer. You are also one of them.
Yes.
That is the school managing committee, district inspector of school of the secondary education, central commission,
yes,
West Bengal Board of Secondary Education,
my lord,
shall consider such transfer application with such time as may be specified by the state government by guidelines. So
guidelines are there.
Upon submission of an application,
SMC
school
shall.
managing committee shall
Shall.
verify the service records and other details of the applicant, examine whether any departmental or judicial proceeding is pending or being contemplated. C. Consider the numbers of the subject teacher and roll strength. If resultant vacancy of the school in particular subject becomes 0 or not commensurate with the roll strength, the SMC shall not forward the application. Then I will go to 3rd January. Don't worry.
All right.
It is after that.
It is after that 3rd January.
Yes. Then
consider
the total application for from the school is not more than 10% of the total teachers' strength. Dispensed with. Now, C and D, which is a very important one, roll strength and subject matter. Of this sub rule for application made on the ground mentioned in 4A to 4D. 4A comes gynecological, serious gynecological disorder.
Yes.
It comes under 4A. So C and D will not be taken into account.
Consideration.
Correct. Now, provided that while considering such application, if resultant vacancy of the school in particular subject becomes 0 or not commensurate, the SMC shall approach the CSC, means the Central Commission, through such and such for filling up the vacancy. So you can't stop it.
No.
You can approach.
Yes.
Provided further that make endeavor to fill up such vacancy by any incumbent whose application for transfer is fit for the aforesaid vacancies and all everything, then cost to examine the applicant by a doctor, provided. Then what it says, cost to examine by doctor SMC in case of a transfer application made on medical grounds mentioned in A, and must indicate the disease which is of serious. So, it is not the medical paper he has to. It is your duty to get it examined.
Yes.
Have you got it examined?
My lord, kindly sees.
You got it examined?
We have
objection certificate. Now, what you have done is, you ought to have immediately say that you are asking, please go before the medical exam. You did not. You did not.
After taking resolution, all the documents has been provided to the DI.
Sir,
this is the fault on our part.
So if you do not follow, then what more? You can't say. You can't say that I will not follow this.
My lord.
Why they are supposed to do? Because that's not a mandate. It is given.
Kindly is twofold. Kindly come to that proviso clause.
Good duty.
That proviso clause kindly sees.
Please read.
E, second proviso.
Yes.
I am before your lordship for interpreting that issue, because I am encouraged by 10C provision. It is now valid. Now the school authority.
Sir, kindly visualize. I read it for you. It says that you can't stop this.
No, I cannot. I cannot. I am not standing
the
in the
only thing is that you will have to approach the Central Commission.
Not
Commission. CSC.
My lord, School Service Commission. Yes.
That is a central commission. They
Yes,
have
yes,
said,
yes,
okay.
yes, yes, yes.
At the top central commission, they
Yes,
have
yes,
used
it is
the
there.
word.
It is there. It is there. Incumbent and an application
So
transfer is
you have to approach them. So look,
through.
this is what the application has come.
Yes.
Now, please consider so that you can fill up the vacancy. That's all.
Yes, I have to do. I have to do what I am before your lordship. If I get the medical documents, then what SMC school managing committee will do? Kindly sees that causing examine the applicant by the doctor of the that means yes, that is
Why
BMH.
you did not do it?
Yes, it
Why
could have
you
been.
did not do it?
Yeah, it could have been unless I get this document. But kindly come to page 21. We take the resolution also.
What resolution?
Kindly sees.
What?
Kindly sees. Page 21. We have taken all this care, but except that medical examination, since we did not get the documents.
Are you supposed to get the
We could
document?
have.
I am
We
just saying.
could have said her.
Sir,
Give all these documents so that we can examine.
why?
It is the fault.
Why?
That part is
Then
the fault.
you are really acting against the mandate of the rule.
Obviously.
Then
Obviously. Kindly
why you have a grievance?
Kindly come to page 21.
That's why I say I'm just quiet. You complete it, then I will see.
I told my junior, my lord, that is to be. That is, it could have been done. That could have been done. First, after getting all these medical documents.
Who are the constituents of the managing committee?
My lord?
Who are the members of the managing committee?
Members of the managing committee includes the BMH. There are another 72 rules.
No, who are they?
The guardian representative, teacher representative, headmaster, and secretary also part one government nominee, including BMH.
And what is the income of the school?
Nothing.
No. Any independent source of income?
No. Composite grant, only composite grant.
No,
now also
income of the school?
Some fund from the students itself.
No, not fund. Are you charging any fees?
No. Government sponsored school. Only 240 from the composite grant. That is also not coming regularly nowadays.
240 for the composite
per
grant?
year. Composite grants and some funds from the students.
Is there any student means the independent
students? Yes, 240 most probably they are to provide to the school. I shall check it up. What is
per month?
No, yearly.
Okay.
Meager amount from the charging from the students itself.
And how much students are there?
In the school, 780 or 92.
90.
And 12 teachers only.
Okay.
Ratio is 66, 1:66. And one of the teachers of this particular subject is under the threat of Supreme Court decision, awaiting 2016 appointment. That is then if we get lordship kindly modify, and the honorable single bench directed straightway directing the DI to take a decision. Now we are thinking that you lordship modify the test.
Because
Yes,
you have
it is
not
true.
done anything.
No.
Now the DI is supposed to constitute a medical board, and then the medical board will examine, and then after that
I am not standing in the way since it is a medical.
Says the single bench that you can't sit tight over the matter for all
We have
time to
sent all
come
these documents to the DI.
and stall the application necessitated by a serious disease on a
Yes.
medical ground in this fashion.
My
So
lord.
it is better not to keep this application at your end.
Yes.
Straight away, the second stage says again the medical board has to be examined.
Yes.
Suppose your doctor says that she is fit, then
Both the BMH.
I am asking.
No,
And-
it can be. It can happen.
And the medical board says no.
It can
serious
happen.
disease.
That is
Then
why double checkup. By the BMH.
which one will prevail? Medical board consists of several doctors.
Yes.
I think more than one.
One. It should have been.
Your doctor is single.
Single.
So which one?
And in that case also CMH
So
one.
it is what CMHO is. See, that's the designation. But the board may consist of several doctors,
Maybe.
including CMOH.
Including CMH.
What is the meaning of the word board?
Board means there are more than one.
Correct. Correct.
More than one.
So let them.
Yes.
The further minds will take care of that.
Now, my lord, may I
Why it
subject?
will stuck up at your end?
I have not stood in the way of. Well, kindly page
We
41
will
also.
say not
have
necessary, but we'll say that ought to have been done.
What to have been done.
Since it was a special case where you sat over it and insist for something which is absolutely alien to the rules.
No, it should be within, or it is within the rules. We did not follow.
How can you ask for a document? Tell me.
Because
your rule,
for the purpose
when
of,
you are taking us to a resolution, tell us under what provision of law you can ask.
along with that application supportive documents.
There are those to us that the rule mandates that you
in the
should
portal, with supporting documents, that what is there?
Suppose the supporting documents are not there. Does it mean that it becomes invalid?
No,
So,
but
because the rule says, I am there, I am suffering from a serious disease of this. Then immediately you will call the doctor and then get me examined.
Yes, that could
The
have.
doctor will say that whether this serious illness is there or not. That's all. Finish.
That's all. That could have been. That could have been. Yes, some guidelines were there that some supportive documents should have been included with the application in the portal.
What
that is
guidelines? As
that
a statutory force?
That not, but some guidelines. Sir.
What guidelines?
Guidelines kindly see in the Utsosi portal is there. Well, this is not, do not have any statutory force.
Then how
But
can you mandate?
some guideline has been framed to give some precision. Otherwise.
And what is the date of the application and what is the date of the resolution?
Resolution.
What is the date of the application? And what is the date of the resolution?
No, I'm giving 2 dates.
These 2 dates given.
Resolution date 30th September.
30th September
2029.
Date of application.
Acha. 20 first resolution 22.
Which application is taken care in the resolution?
28th of June 2022.
28th of June 2022 was the application which was taken into consideration in this resolution.
This resolution, my lord, is subsequently made in 2024. That is the last application. Has to be that one, because that is the last application.
Resolution date.
I'm checking the
September 2024.
30th
September.
No.
2024.
These 2 dates are alarming, sir. That's why I.
Subject to correction. In that track record, he is saying 2022. Probably this is not correct. If you will also kindly come to page 41. First application 38/2021.
Sir, they're more alarming.
First. And we have taken.
I will take that.
No, I must be candid to your lordship.
Then he will not oppose to it if you take 21 application.
And that resolution, page 39.
Is of 30th of September 2024.
There is after the repetition file, resolution taken, forwarded to the DI, taking all these measures, what is to be done. This is our stand.
Correct.
Now, initial resolution, page 39. That is 23rd of February 2022.
23rd
February 2022.
23rd February 2022.
Yes.
What is that resolution?
Page 39.
What is that resolution?
Oh, yeah, page 40.
Page 40 September 2024.
That is the second resolution after the court case proceeded. And DI took. And page 40 is the initial resolution. Page 40. May I read for you, Lords?
My brother is more conversant than you.
Get for
COVID-19 এর কারণে বিদ্যালয় দীর্ঘদিন বন্ধ থাকায় এবং তার প্রভাবে ছাত্রছাত্রীদের উপর ব্যাপকভাবে পড়েছে এবং সেই ব্যাপারে আলোচনা করা, অভিভাবকদের যে ব্যাপারে সচেতন করার প্রয়োজনীয়তা রয়েছে, বিদ্যালয়ে অভিভাবকগণের মিটিং ডাকার প্রয়োজন। হয় যে তত দ্রুত সম্ভব বিদ্যালয়ের অভিভাবকদের মিটিং ডাকা হবে।
That is no resolution regarding this. What is the resolution?
Page 40.
Page 40, nothing.
Yes. First paragraph.
First paragraph, what is this?
That Utsosi portal such and such ground medical ground আবেদনের ভিত্তিতে NOC এর আবেদন করেছেন।
উচ্চশিক্ষা পোর্টালের মাধ্যমে মেডিকেল গ্রাউন্ড
উচ্চশিক্ষা পোর্টাল
আবেদনের
শিক্ষক শিক্ষিকার সংখ্যা
আবেদন করেছেন। আলোচনান্তে সর্বসম্মতিক্রমে সিদ্ধান্ত গ্রহণ করা হয় যে বিদ্যালয়ের বেশ কয়েকজন শিক্ষক শিক্ষিকা উচ্চশিক্ষা পোর্টালের মাধ্যমে জেনারেল ট্রান্সফার নিয়ে চলে যাওয়ায় বিদ্যালয়ের বর্তমান
পার্মানেন্ট শিক্ষক শিক্ষিকা সংক্রান্ত লক্ষণীয়ভাবে কমে এসেছে, যা বিদ্যালয়ের পঠন পাঠনের উপর বিরূপ প্রভাব ফেলেছে। এর ফলে বর্তমানে আর কোনো শিক্ষক শিক্ষিকাকে এনওসি দেওয়া সম্ভব নয়। তাই
Now,
সহযোগিতা মানসিক
3rd January 2022,
খারিজ করা হয়।
thereafter no proceeded, no proceeding.
This is the 23rd of February 2022. And there was a further application on 28/6/2022. Earlier applications 2021, you did not take. I have seen that page 40. What resolution?
Not fault. There are some fault. It should have been. It should have been proceeded. In the medical ground, it could not.
We are
No,
imposing-
kindly.
we are imposing use cost on the school. That's why we asked that who are the members.
No,
Because
kindly do not this.
the
No,
government-
we shall.
Government, we will not impose anything on the government. We will impose a personal cost on each of the members to be shared. with the government.
No, we have already done. No, page, kindly
Don't
come.
do that. Don't
Page
do that.
45. Page 45. We have taken all this course
Yes,
and
yes,
sent
don't
it
do-
to.
When?
Okay.
When?
We shall do this. I undertake
there.
on behalf of my client.
So
That is why one interpretation is
How
required.
many members are there in the managing committee?
কত হবে? 14টা বোধ হয়। না, না, ওইখানে তো সবাই থাকে না।
Well, it is relevant, my lord, from the resolution that there were 8 present at that particular time. 8
Eight.
present.
Total members most probably 14.
So the salary must be in thousands.
There are no salary, my lord, for the members of the managing committee.
They are earning.
Yes. In other ways.
They are earning. So at least nowadays, 2,000 rupees each can be spared, no difficulty. So 8 members, so 16,000 rupees is the cost to be paid.
Subject to correction. No, subject to one. That interpretation, my lord, kindly do this. 10C to be invoked so that
Then we are imposing 5,000. How much? 40,000.
no, my lord, I leave it to lordship. That should be after some my lord, examination of medical documents.
It is a sordid state of affair that the school, the managing committee of the school,
For that, your lordship will kindly see his lordship's report
Managing committee.
That should have been, my lord. I understand. And I also, my lord, not in standing in the way. That is why.
Gynecology disease রয়েছে. Look at the thalassemia. Transfusion is required anytime.
Yes.
And you are not processing the application.
But this is with
I know serious gynecological problem. I'm just giving an example. Thalassemia.
And that is to, my lord, only 6 diseases are coming under the rule.
What I'm saying.
There should have been 21 diseases. One petition I moved that is pending. In terms of, my lord, Right to Disability Act 2016, there are 21 diseases, or Parkinson, all these things are not there. Along with other diseases. Central rule says 21, they are saying 6.
School.
Before your lordship, Mr. Rai Mukherjee is appearing for the respondents Paschim Bongo Samagra Shiksha Mission, your lordship. Your lordship, his father passed away, your lordship, in last week, your lordship. Therefore, he has not coming to court.
My lord, this is an appeal by the state. Will you lordship kindly hear us? This is an appeal by the state. He has got no say to this.
The council is appearing. And in such a situation,
And then you lordship kindly fix a date for hearing. Because we have mentioned this matter because from 2012, after all, we succeeded in 2024. We cannot wait for the state government.
Bongo Samagra Shiksha Mission, your lordship.
on behalf of
Respond number 10.
record of
Not a
respondent number.
Respondent number.
I'm the appellant. This is the matter that there was a difficulty when the appeal was filed with leave to file the certified copy, but in regard we have the certified copy, but this is not the same certified copy which was obtained. We have made an application to that effect, my lord. Application to Can 2 of 2025, my lord.
I am for the appellant, my lord.
I'm for the statement.
I'm for
My lord, this, yes, my lord.
We are the petitioners.
Can 3 already allowed, my lord, this,
One of the writ applications appearing.
can,
Can please.
Oh, can 3 is there?
can 3 no, my lord.
2.
Can 2.
What is this can 2?
Can 2 is a stay of the order. My lord,
We are the one of the
This-
petitioners.
my lord,
What is can 1?
this matter, my lord,
Not the party. Again.
Yes.
my lord, this matter relates to,
Condone the delay is can 1.
yes.
Then can 3?
No, can 3 is not here, my lord. Can 1 and 2.
Condone
2
the
is a
delay.
stay application.
Condone
One
the
is
delay
a-
again. Why 2 applications? Can 1 was oh,
One is
can 1 was directed to be withdrawn.
Yes.
Yes. Can 2 is the stay application.
Yes, my lord. My lord, this matter is a unusual matter, your lordship.
So
Yes.
unusual approach is required.
Unusual in
Unusual order is required. Just
You-
have,
my lord,
just wait, just
Yes.
wait. Let us see what is unusual here.
after change of
Just wait.
কবে চেঞ্জ হয়েছিল চেঞ্জ হয়ে গেল 28 ছিল 28 অক্টোবরে চেঞ্জ এটা তো ওরই যে বলছি চেঞ্জ কবে হয়েছে তো লিখেছ দিয়েছিস
Who are you?
my lord, my lord,
Who are you?
my lord, I am the headmaster, your lordship.
No, no. There is a. You are a suspended headmaster.
Yes, my lord.
Why don't you provide a key? Why you are not providing a key to Almiras?
That happened, I just pointed out. My lord,
My lord,
please
kindly see, my lord, this matter relates to,
I do not want to go into the order which is impugned herein. Is very clear.
we are not the party. We
my
are
lord,
the
situation is, my lord,
Who are you?
my lord,
We are the writ petitioners in WPA 28983 against which this stay application has been. My lord, kindly seize the.
No, no. You are.
the party.
Please tell me.
Fine.
This
Hooligan
arises from
teachers.
WPA 22153.
That is.
Are you a party?
No, not.
You are not a party. Correct.
28
Who are you?
We are the writ petition is 2898.
We do not want to know. Who are you means not a writ petitioner.
My lord, that-
What
we are
is
the-
your designation?
We are the certain teachers, my lord, we are the assistant teachers.
That's all. This issue concerning the audit to be done, the Almira is kept under your key. The single bench has directed the administrator to break open the padlock of the Almira, make an inventory in presence of the local police stations, some personnel, and then put it again into the Almira. Certain documents which the auditor requires inspection, that was also provided by the administrator. So this is the only thing. Why
that
you
is
will
not
have-
the issue, my lord. Issue is this, my lord.
So this
My-
order,
my-
if it is
after
not,
change of determination,
then other issues are not decided. The matter is still pending. Go before the single bench, raise all the
no,
issues. there.
release the matter, my lord. When
Not release
kindly,
the matter.
kindly submit, my lord. Kindly submit, my lord. I came to High Court for against the hooligan teachers. Those are disturbing me. But, my lord, section 5 was addition of party application was filed. Thereafter, my lord, they are allowed for on the same cause of action, my lord. Their writ petition, so that is barred by res judicata. So that matter is continuing. So after change of
My lord, may I
determination,
submit-
my lord,
may I
after
submit
change
one
of
thing?
determination, my lord,
My lord, the
the
petitioner has
landlord
been
single
suspended.
judge continue the matter. When I
Showcause
file
issued,
this appeal,
not replied.
the
Charge sheet
landlord
issued,
single judge
not replied.
release the matter
Proceeding concluded. Final order passed.
and keeping my petition pending.
My lord. On that date, matter was part heard, my lord.
Yes.
Relevant portion, page 66. Heard in part.
That is hard in part, but
yes,
once that was after my lord, division bench order, that part is deleted.
where is the deleted?
Can you see, my lord?
Show us where is the division bench says it will not be treated as added part.
No,
Show us.
no such order was
Show us.
passed.
Show us.
Kindly see, my lord.
Please show us that this part heard has been either, I would say, cancelled by the judge, or a division bench says that it cannot be.
No, my lord. After
I am asking you, sir.
After change of roster,
I am asking you.
after change of roster, my lord, can this part be continue, my lord?
Tell us that where is
chief
the
is
mandate? I am asking you, where is the mandate? It says that the part heard shall stand immediately cancelled.
Division
in
bench,
the event
division
there is a change of determination.
My lord, division bench does not say that part heard be
I am
deleted.
asking you, sir.
No, division bench does not.
You are raising a point that the moment the determination has changed, the part heard will not remain. Show us any order of the Chief Justice, of the High Court, that it will automatically get cancelled.
Yes, my lord. Kindly see, my lord. Kindly see the judgment, my lord. But I am relying upon, my lord, two judgment, my lord, of my lord, State of Punjab versus Davinder Singh Pal.
Sir,
Kindly see.
you have not understood what I want to say.
But
I am conscious you are going to Punjab. I am conscious of the Supreme Court judgment.
Yes, Supreme Court judgment, my lord.
Supreme Court judgment originating from a Rajasthan High Court.
Yes, State of Rajasthan versus Prakash Chand, my lord.
I know what was the fact.
My lord, after change of roster.
No. Then I'm telling you, because one of the honorable judge, one of the honorable judge from our High Court took a very bold decision in that judgment. You know what has happened there?
appearing for the appellate. Your Lordship, he is on leg in court number 4. Kindly, grant 1 day's accommodation, Your Lordship. Grateful, Your Lordship.
May put, please, Your Lordship, I am for the appellate. Last occasion, there is a direction to produce the certificate, schedule caste certificate by the state authority.
You were supposed to submit a report.
My Lord, can you see Rajendra Rajo?
I have already seen.
Well, I have seen because I wanted to get a copy. Picture on the is a different man, Muhammad Yuku. All his document he produced, all manufactured. My Lord, can you see the certificate issued by the district manager Alipur? The picture of the left-hand side bottom is a different man. My Lord, can you see?
Are you aware?
I have.
How we know?
And the person is working there is a different man. My Lord, can you see? Muhammad Yuku.
No, certificate in the name of the Raja.
No, I have seen that, but picture is different. My Lord, can you see our certificate? My Lord, can you see our certificate? The false, my Lord.
How it is possible?
If Muhammad Yaqub is and the man is working in the school is a different from the picture.
There's somebody by this.
He should follow the district magistrate.
My Lord, can you see the picture? My Lord, my picture, can you see? Because he is applicant, my Lord, he has manufactured.
How much of energy it appears. You are aging. We are also getting some MD. I do not know what is there.
So far, I have seen.
But there are certain things which are really illegible.
Yes.
You don't know that he may be some authority.
No. On picture, he has to sign. Well, can you see our certificate? Well, can you see our certificate? Well, can you see in state petition annexure P3? No. Well, can you see the application page 11? My Lord, left hand side, bottom, my Lord. This is the appellant here, signature and the sign. And this is the certificate. Also, the same, it will be, the same name will be there. It's a different name, different person, my Lord. Not only that, all he is produced in the department, all are fake, manufactured, even the certificate, his qualification, everything.
Have you ever checked it?
This is my Lord. Yes, my Lord, we are having this. My Lord, this is we have.
Of the authority, no. Whatever is submitted to you is one thing. What you got it, you are giving it to us.
Yes, my Lord.
But once, this is a very, I would say, very incriminating things that he has brought. That on the photographs, somebody has to put his signature, self-attested. Signature, it appears that some, the rubber seal is there. I do not know what is the.
That is Muhammad Yaqub, that is LA, I presume, my Lord, LA collector or attested. That, my Lord, till now.
You have to approach this authority.
Yes.
You are a state.
We shall get it confirmed.
They must have kept the record because once they give a number,
Obviously, ma'am. Yes, ma'am.
so they must keep the record. If the record shows the same thing, we will ignore him. Don't worry. If
No,
he's an ordinary
what has flown from your lordship? Yes, ma'am. We shall confirm. Till now, my lord, this question has not. Now we shall get it confirmed.
no mandate that it's to be self-attested or like
No,
this. You can attest it. Authority has put a seal. That's enough.
yes, I shall get it confirmed.
That's enough.
Probably it has been attested by the summers. No,
Attested by the
headmistress of this school.
ঠিক আছে মাইলড বলছেন মাইলজ বলছেন যে একটু কনফার্ম
Who are the guys with this? You have to match him.
But the very interesting, my lord, I am for the, I am
Because I
for
find
that
from
gentleman,
page whatever,
he was not party in the writ proceedings. How the
Whatever.
memo of appeal I have been included. That part is over.
must be an earlier order.
No.
No, there is a stamp reporter ছিল ওটা
I don't know, my lord, what is the report of the stamp reporter. I was not party in the writ proceedings. I was not served. Now the memo of appeal I have been included.
How can you plead him as a
No, order of the order of single bench. There is my lord, deleted the party, my lord. Earlier occasion, my lord had passed an order to deleting his name. Order.
So his
Yes.
name has been struck off.
স্টাফ
staff
বাদ দিয়ে দিয়েছে
Oh, yes.
We have asked you. Say you can't plead him. Now tell us.
We shall, my lord.
Inquiry.
Yes, we shall get it in confirmed from the only in South 24 we shall get it.
So by an order dated
ওটা মাইলটের কাছে থাকবে।
Since the my client has been stuck up for the appeal, but the your lordship, since the my appointment has been challenged, well, I may be allowed to as intervener, my lord.
Then you make an application. Next.
Sir, I appear on behalf of the appellant.
The DPSC.
That, there was a delay of 50. Your application for condonation of delay. Delay is 55 days.
How much days delay?
55 days.
55.
And the reasons for delay, Millard.
What happened?
Now, Millard, I tell you, Lordships, Millard, so far the present matter is concerned.
No, in absence of any scheme.
Yes. I'm grateful to my lord. Your lordship, Millard. Yes, I am grateful to Millard.
What has happened to Binapani Murmu, Supreme Court judgment?
The particular Millard case, which my lord's Millard on the last occasion had Millard wanted me to peruse, was the judgment of State of West Bengal versus Debobroto Tiwari. And this judgment was referred to by the learned single judge. Now, Millard, I have perused the judgment. This is the judgment. I have brought the judgment.
There is another judgment.
Yes.
We have adjourned the matter, many matters. Binapani Murmu.
Binapani Murmu.
The same thing happened. There was no scheme.
Yes.
The division bench of our High Court held that there is no difficulty in granting a compassionate appointment and directed the appointment to be made. The state challenged the same. The apex court has admitted the special petition, leave granted. The matter was pending. So I just wanted to know what is the fate of
Binapani Murmu. Millard, then I have to take at least 1 day time. I can only, Millard, get the status of the case. I cannot say anything more.
It has been disposed of. If it is disposed of, you can bring.
Yes, if it is disposed of, I can bring. Otherwise, Millard, I can only bring the status report. Not today, Millard. Then, Millard, yes, that will be better. I think. আরে দূর ওটার কথা হচ্ছে না। I am being given an impression that since Millard, this is against the Bardhaman University and there is no scheme, therefore this matter does not cover. Millard,
That is the main point was in the
yes, your lordship's Millard query is that if there is no scheme, then even then whether compassionate appointment can be given, because this is an exception to the general rule of appointment.
That is what I wanted. So that is what the Supreme Court has already issued a notice.
I'm grateful to my lord.
Please consult that.
I think the Binapani Mumu is still pending, I think, pending before the Supreme Court. I will show you the judgment. If the matter is pending, I will show you the judgment.
Postpone the hearing of that.
No. Next week, we will find out the judgment. Monday, my lord, we will find out. If we will find out, your loss, I will produce the judgment.
In another, my lord, in 2013's Sinana something that judgment, 3 judges bench of our court, my lord, with regard to this issue, my lord, 2 years has been completed. Now, that 3 judges bench hold, my lord, that there cannot be any extension of time with regard to compassionate appointment. I will bring that also, my lord.
Yes.
That also. Why you have framed so many schemes, amendment have been brought.
That is, my lord. That's the theory is also there. All the
5 years period is extendable. Why you have done so? Then
that is precise on this point, my lord. That
Make an uniform rule, then Millard, whatever you want to do it.
Lush, get to
I'll get to
Call the next. What is this? What is this application?
Application for on a condonation of delay.
Have you read the recent judgment of the Supreme Court, where the Supreme Court has made a very pertinent remark that we are astonished at the state coming up with the appeal or a special application with a delayed application? Who is responsible for giving an advice? What is taking care of is afterthought concept.
No, that.
Yes, they're also
163 days delay.
they're also the long delay.
163 days.
They're also the long delay.
No, here is only 163.
They're also a long delay. 200.
163 days.
182 days, our reporter said. 18 days is hardly anywhere. 200. What to do?
No. If your lordship finds that if there is a merit,
Patiwala, they have made certain remarks. What to do?
if your lord finds that there is some merits in the appeal,
that was not taken into account. Have you got that? Nowadays, find out. Yesterday or day before yesterday?
I'm a layman, that's a.
You are not a tech-savvy man. You should embrace the technology.
That's a difficulty. It is a high time.
What I'm saying. That is why I'm saying. Take an assistance from your junior. Why they are not so updated?
Under the same landed, but just same landed judge in another decision in a similar issue, passed an order that state government is not responsible. But the landed single judge in the same issue in this case impose the financial liability upon the state. Because the scheme of
God, this is Patiwala.
Yes,
sitting with
Justice Madhavan. Justice Madhavan. 8th January.
Today, 8th January or recent?
Yes,
February?
8th January 2025. 8th January 2025.
2025, Judge.
Yes, my lord. 8th January 2025.
There
8th January 2025.
also this.
Yes, my lord. 8th Guruswamy versus 8th Special Assembly.
No, it was a state versus. It's a state appeal. Just recently, you go yesterday or day before yesterday.
It's a state appeal delay from
It has not been decided finally, but there was certain remarks.
Judgment
On a live law.
that is from line law. There are two judgments which are showing.
Sure.
Delay cannot be condoned based on merits of main matter if there is no sufficient explanation of delay.
So, my lord, there is
sufficient explanation.
explanation is
Please remark that why they are delaying. When they suddenly woke up, why they decided to prefer an appeal? Why not promptly action is taken?
There is concern. But we cannot file an appeal without the permission of the Allied Legal Review. And Madam, as soon as, because we are under the impression.
section 5 application টা নিতে বলুন 163 days after
Our stamp reporter has.
my lord 163
Our stamp reporter is.
my lord not disputing
That was 656 delay. Ashok. That was my lord 656 delay.
Okay.
I am Kullan Banerjee.
Huh?
Oh,
Okay.
that was how much? The recent, I think the recent one. I think the day or just yesterday or day before yesterday. There was one matter. Mr. Additional Government Pleader, you have taken. I have read your paragraph 4, 5, 6. Do you think that because of the ensuing parliamentary election of 2024, the legal remembrancer remained busy with the parliamentary affairs?
No.
The election.
No.
I think the legal remembrancer is a judicial officer.
No. The applicant
He is away from that.
The opinion of the legal members are on 7th June after preparing appeal against the order, open order against an appeal.
What?
7th June approval we got from the legal member.
When the parliamentary election was held?
In the month of April. Result declared in first week of June. 4th June. 4th June, result was declared. Or 6th June was the both checking ceremony.
I believe that even a code of conduct does not really put any fetter on the part of things.
No. Because some of the officers have taken rescued by requisition by
disclosed by an order that they were posted somewhere else at the distant place. You have not disclosed it.
due to engagement of the officers in the
Paragraph
the department
very vague one. That because of the parliamentary election, the officials were unable to proceed further. Nothing. Who was that? Who was the officer? Where he was posted? Where he was engaged?
This type of one man not. There are several persons. I will go through several persons.
Tell us that who are the persons, because there is one judgment sitting in a division bench of which I, along with the single judge who has passed the order, was a party.
The appeal was filed in November, 19th November. Para 11.
No, but Mr. Basu released the appeal could have filed, that was filed only on 14 November 2020.
The appeal could be filed only. Basu's illness.
9 July.
When, what illness?
Then my became sick. Then it was filed on 14 November. And it could be filed on 19 November.
Is this a sufficient explanation?
Can you see paragraph 10 and 8?
I have seen 4, 5, 6, 7, 8.
Okay.
You are putting a shelter or really blaming it, Mr. Basu.
No, I'm not blaming Basu.
Mr. Blaming. You are blaming him that he
No.
did not prepare.
No. It
Due
is
to his illness or other way.
No. 9 July was made ready on 30th of July. But in the meantime, Mrs. Basu became.
I'm saying you are putting up to.
No, I'm not saying that. But if I am taking the responsibility myself.
He could not find time to consult you. He could not do anything. That is means you are really taking the responsibility.
No. One of the Kanishi. If there is an intentional delay, there is a different thing. There is an unintentional delay. But we shall have to proceed on the basis of the procedure prescribed under the law.
But the explanation is very vague. You have to say that which officers was there in the helm of the affair. That is not there. Where he was engaged. Where he was engaged.
We shall have to rely upon the officers. We shall have to rely upon the officers who are dealing with the court of.
Who has affirmed the affidavit?
Can you see that he has affirmed the affidavit by just give me one. Kaushik Kumar Mukherjee,
No.
Joint Secretary, Department of Agriculture Department.
Let him say. He has affirmed this paragraph as true to his knowledge.
No explanation between June and November.
It's about to be there. That is the explanation. What more?
He looks really healthy.
Yeah, that's an explanation.
But the date of his illness is not mentioned. That from June.
Not realizing that what they have done. Everything on the shoulder of Mr. Basu.
Mr. Basu was not there, not even there in the writ court. There are different set of learned lawyers were there.
Dismiss.
Up to your lordship. It is up to your lordship.
Sufficient explanation.
In my respectful submissions, but what are you? Can not take it otherwise. My lord, while exercising the power under Article 226 in a single bench or division bench, is there any limitation that has been decided by our full bench or high?
Mr. Mukherjee, then let us go on an academic basis.
Yes, madam.
Let us go on a.
Madam, this has been held by Justice Prabhashankar Mishra, Justice.
I am talking about one thing. The writ jurisdiction exercised by the High Court came only after the adoption of the Constitution of India by the people of our country.
Yes.
Definitely after 26th of January 1980. There is no provision under the Constitution of India providing a for an appeal against an order passed by a bench exercising jurisdiction under Article 226. Do you find any provision in the Constitution providing a avenue of appeal?
No. Only latest.
So our High Court is guided by a latest patent.
Latest patent.
By virtue of clause 15 of the latest patent, it is there. And it is by virtue of the latest patent the limitation comes.
But that's has been discussed by our special full bench.
By virtue of this, the limitation comes.
Yes.
If there is a limitation for filing an appeal, there may not be a limitation for filing 226. But an appeal, definitely.
But this has been discussed.
Why you infuse both Article 226 jurisdiction and an appellate jurisdiction exercised by the division bench?
What power will exercise? Why not we exercise the power under Article 226? Not.
Sir, that's why we are exercising power under the latest patent.
Latest patent procedure for appeal.
No, it's a right of an appeal. And if a right of an appeal is provided, then in that event, the appellate restrictions has to be imposed. Why we frame the rules?
Your lordship framed.
Why we frame the rules for Article 226?
But kindly consider.
So this is what the rule has to be given.
Yes.
Then the appeal is to be guided by certain provisions. Appeal is not unfettered or unfettered, unregulated by any kind of a procedure.
No. But that's why not
Right.
Limitation Act.
So if it is there, then the appellate court is looking at the thing whether the order impugned is justifiable legally and factually. Both. See that. But if the period of limitation is enshrined, then what you are saying is that a person, if there is no period of limitation, a person may challenge the order of the single bench after 10 years.
No. Certainly not.
No period of limitation, sir.
That's why Justice NPC 1996 Supreme Court said, put on procedure.
Sir, what it says is that there must be a close proximity or nexus, so far as Article 226 is concerned. But when the period of limitation is provided under the Act, it says that an appeal shall be filed within this period of limitation. Then that period has to be understood in that sense. And it is not inflexible or it is not flexible. Power to condone is definitely conferred.
Yes, in the discretion of the court.
You cannot say no period of limitation. So nothing.
No, but I'm not. Within the reasonable time.
Article 226. But appeal arising from Article 226, no period of limitation. Is it correct?
No. That's why our full bench decision, full court decisions, AIR 99 Calcutta, page 29. Ratholal Lahata versus.
That's a special bench judgment of 5 judges bench,
yes,
headed by Justice A.M. Bhattacharya.
No, Justice Probation Court is the first judge. Second judge, Justice H.B. Sinha, Justice Nuri Alam Chaudhary, Justice Barin Ghosh, and Justice, but total 5 judges are there. For the deep 89 Calcutta.
I know, but that is the judgment. Have you read it?
Paragraph 75(1)(1). Justice Sinha said, majority, I think practically, judgment was written by Justice S.B. Sinha because when exercising the power, appeal court, exercising the power under Article 226.
What a concept, because we can upset the order and issue a writ of mandamus sitting in an appellate.
Yes.
That is the different. Again, I am saying, I think there appears to be a confusion in your mind. Suppose an appeal originates from the order passed by the Presidency Small Causes Court, which is governed by a Presidency Small Causes Court Act, providing a certain entire mechanism to be done. The appellate court can go beyond the Presidency Small Causes Court because it is an appeal under that act, and the act has to be taken into account for the purpose of an appeal. Correct. Yes. Similarly, what you say is a different, but you cannot infuse both. That for Article 226, no period of limitation. So an appeal, mandamus appeal, no period of limitation.
No, I'm not saying that.
Because it is originating from Article 226.
No, I'm not saying that. I'm not saying that. As
wrong, sir. The way you started, I think my understanding may be wrong.
No, Justice
I think everybody present here understood in that.
No, Justice NPC 1996 Supreme Court said that because Civil Procedure Code does not apply in a death proceedings, Limitation Act does not apply, but within the reasonable time.
No, that is what our High Court has clarified this of Justice L.M. Ghosh. It says that if there is a normal period of limitation for filing the suit, then at least that period must be taken into account for leaders. If there is any other delay which has come, then one has to
consider.
One has to explain it. So this is the another concept of the original jurisdiction. But I'm talking about the appellate jurisdiction.
That's why you have said, say, 137 and calculation on that.
So you have to give an explanation. If you say, I am ready to deliver a judgment saying that yes, limitation intervenes, and in absence of any sufficient cause, can't be condoned.
That's why you have calculated 30 days from the date of the order.
That the difficulty understanding is this. If you applied for a certified copy within the period of limitation, then you are entitled to an exclusion of the time. Yes. But if you applied the certified copy after the limitation period expires, then the entire period from the date of the order has to be
calculated. Take it into consideration.
But I entirely including 30 days.
But I leave it to the entire answers discussion either to
No.
We have nothing to say. Appearing for the state.
Then it's better not to open the Pandora box.
But kindly consider.
Don't open a Pandora box.
Your Lordship, kindly consider whether we have got any merit or not. Nothing more.
Can it be? Have you seen the recent judgment? The Supreme Court says that the merit cannot be a criteria. You have to decide the application on the sufficiency of the cause. Have you seen that judgment of the Supreme Court? That is judgment. That the Section 5 has to be decided on the parameter of sufficient cause, not on merit of the main matter.
My lord, that is 656 days. I am Mr. Bandyopadhyay speaking.
Yes, 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 Mr.
656
Bandyopadhyay,
days.
Mr.
My
Mukherjee
lord,
has
that
opened
is
such a
yes.
Pandora
Oh,
box. We have to.
no, my lord, it is my lord, the case which your lordships are referring, that is 656 days, and in a second appeal.
Yes, that was the second appeal.
Is
at
Padiwal
the
judgment.
case of the state.
And 4th February.
Yes.
Yes, 4th February judgment was delivered. But
Yes,
delay
that
was
is what I was
656.
talking about 2-3 days before. 4th February
Yes,
is yesterday.
4th February.
Yesterday.
Yes.
So,
Yes, 4th February. That is
My lord, you leave it to your lordship this case. I'm sorry, hold on, your lordship, that is okay.
Mr. Mukherjee, what to do? Tell us.
According to my instructions of my learned lawyer, according to his understanding, when he proceeded on the basis of a drafting, tried to explain his delay in filing the appeal. It is entirely after discussion of the board whether we have sufficient cause.
So no obligation of the member of the bar.
No, what are obligation of the bar? We cannot impute the facts. We can show the law, but we can argue on the law. Facts will be decided on the basis of the pleadings made by the party. Because I'm bound by the instructions of my client.
You are a creature of an instructions.
Yeah.
What more you can do?
I think your lordships would condone the delay and hear out the appeal any day convenient to your lordship to take not more than 10 to 15 minutes. But because the point is very short. Point is very short. Because of section 3 of the Control of Expenditure Act, if post is not sanctioned, and if there is no approval by the state government, whether it is entitled to financial benefit for the government. Because it is a central government scheme. And the learned single judge in another case, in the same department, rejected the petition because of the central government's liability.
Because of?
Central government's liability.
And allowed this writ petition because of the?
In this case, a writ petition has been allowed. In another case, writ petition has been dismissed.
No, why you used terms, two expressions you have used? I just wanted to have a clarification on that.
The
other Mr. Mukherjee, you have used two expressions. What is that? No, in an earlier matter.
Earlier matter, I appeared.
Dismissed. Why?
By the same judge.
Why?
By justice.
Why?
Because it was a central government scheme.
And why it allowed it here? Why it allowed it? Because of? Because of?
Because the government has representative in the council or the body in the university deemed to have been approved. I have not seen such a law. If government nominee is there in a body, that's why all actions to be valid. University is the autonomous body. Government sanctions pays ad hoc amount according to the allocation of budget, not to an individual employee. Well, can you see the language used? The language used, can you see?
হ্যাঁ ঠিক আছে
Finding is this. Huh? What a kind of delay the discretion of the court. We cannot say that.
তাদের জাজমেন্টটা নেই
Oh, sorry, madam.
Bench at 3.
কি হলো তাহলে এটা? আমিও তো জানি।
My lord.
You have any matter of this
My
bench?
lord. Yes, yes, item 95, my lord.
Item
I-
95, what is this?
Mr. My lord, this is the matter where, my lord, the affiliation was given, not given by the MACOUT, my lord. In spite of her having
No, is my lord.
out Maulana Abul Kalam Azad University.
Okay,
My lord,
I am very bad in abbreviation, so that's why I was.
Naturally, wrong. Why you use this? This is now new
Can we
trend
take
has
up
come.
tomorrow? We are sitting tomorrow again, and we
Okay,
will
my
be
lord,
starting
only one.
from 93 or 92.
My lord, early morning I will be here, but after some time, after 11:30,
No.
I
We will
not
be
here.
starting from 92. Don't worry. So it will be taken up within 5-10 minutes.
My lord, deep love this.
What? What contempt?
Before the land is there.
Naturally,
So we are disposing of you.
Nowadays,
Tomorrow day after. Why you are apprehensive?
nowadays in court, abbreviation is allowed. Abbreviation
No,
high.
No
Yeah,
difficulty. No
all that
difficulty
things
with-
are. No,
No,
that should
Mr.
not.
Bandyopadhyay,
That should not be
I
done.
appreciate. But I am not
No.
very accustomed. That's why I said
No,
I'm not
we are also not. We are also not. In court, it should not be done. In
No.
court, it should not be done.
Yes. Thank you.
আজকে আমার
অশোক, এটাতে চলে।
কি হলো?
অশোক।
What are the contents of court statements? শুরু করবে নাকি আমি বলবো? আমি দিয়ে দিচ্ছি। কি অনিমা কি নাম? অনিমা
Yes.
পিটিশনার রয়ে গেছে। পিটিশনার নোটিশ দিয়ে দিস।
Have you given a notice?
Lordship. Yes, along with this.
Yes, Mr. Advocate General.
Yes, sir.
This is the court.
Yes, sir.
Because we want to settle the law. Who has received? Rudro.
Yes, the advocate on record has received.
About Mr. Swapun Banerjee.
Swapun Banerjee is also accepted on behalf of the state.
I find.
না তুমি সিঙ্গেল জাজের কাছে তুমি পিটিশনার হয়েছিল?
No, he was. You have read it?
No, I was inquiring.
Not. He was for the writ petitioner or respondent. No, he was for madrasa.
Party in the writ petition.
Yeah.
My client, Madrasa Service Commission, was not a party in the writ petition.
Okay.
Now, writ petition was filed that a notification was issued by the state of West Bengal that during the COVID period, who are the warrior of the COVID, if expired, he will be the heirs of the deceased will be compensated by way of a appointment. Now, relying upon the deceased, the petitioner's father was a teacher of a husband was a teacher of a Madhyamik Shiksha Kendra. This is the unaided madrasa. Now, Lordship, the expired during the COVID period. And he filed a writ petition that in terms of this notification, a compassionate appointment may be given to the petitioner, that is the wife. Now, writ petition was disposed of, where we are not a party. Subsequently, the contempt application, when he was appointed in the unaided madrasa, he refused to accept because this is, I want the service in an aided madrasa. Now, Madrasa Service Commission has been implemented as a party. Now, challenging the same, we preferred an appeal. Appeal court has modified. Now, after the modification, when
What
the
modification?
modification, the division bench order I have
No, no.
annexed.
The contempt order was passed that you give them an appointment in the aided school.
In the aided school.
Correct.
We have challenged this before the honorable division.
Then the division bench what modifies that no, it is an unaided.
Unaided, you have to accept the unaided madrasa. The petitioner has accepted. Matter
Correct.
ends.
So that order was placed.
That order was placed.
Now you are very serious. At that point of time, you was not serious.
He did not look serious.
Smile as no.
There's a difference between smile and laughing.
Okay.
The Honorable Court took umbrage to a laugh.
What difference between a smile and a laugh?
Now, I have filed an affidavit as per the direction of this honorable court. Kindly come the order I have annexed, the order of the honorable division.
My lord, I am ready to, my lord, assist your lordship, my lord, on primarily the basic concept before going into the aspect of yes.
There was any interference in the
Right.
of justice by the
Right.
court,
Right.
or if there is any act, behavior, conduct which would definitely tarnish the image of the court, then if any rule is issued or any if notice is issued under the contempt, then it will be regarded as a criminal contempt.
Right.
The criminal contempt can only be decided by a division, not by
Right.
the act itself. I
Under
think
the act itself. Under the,
18 or
yes.
so
Yes.
the contempt of courts.
Right.
That can be done only we punish. Secondly, in order to punish, an opportunity to explain or defend must be provided. It cannot be done in a one go and by one stroke of it.
Right.
That's the preliminary idea which I am carrying, subject to, that's why we need your assistance.
But there is a very old judgment.
Wanted that.
Yes. Where, my lord? Yes.
That
Yes.
far to deliver a judgment of.
But this judgment, my lord, covers both the aspect. First is, my lord, there was an altercation between the, I shouldn't say, my lord, altercation, but my lord, there was some difference in the, between the council and the court. The court had directed the council to produce a witness. The council said that my witness is not a piece of paper that whenever you ask, he can be produced. I am the lawyer. I have a right to produce it as and when required. If not required, I am not going to produce it. At the behest of the court, I will not produce it. Then these things went on. Then the court asked the council to apologize. The council said, why will I apologize? Because I do not know what mistake I have committed. Then this went on, and then finally, the court had delivered a judgment holding that the council was guilty of contempt in respect of 6 acts. And one of that act was to laugh at the court. And there were other 5 contempts. And then the court holds that no, there is no contempt, number 1. And number 2, the other one which your lordships are also requiring me to assist, as to whether the conduct of the advocate is contemptuous or not. It held it was not contemptuous. And number 2, it has also held, like in this case, that suddenly you cannot deliver a judgment saying that I'm punishing you. In that case, it was a fine imposed of, I think, $200. So this is a case, my lord, which I think, my lord, will throw much light on it. Then, my lord, we have our Sir Ashutosh Mukherjee's judgment in 23 CWN. This, of course, is primarily on what is the status of a lawyer or an advocate and what is his function. This is something, my lord, which is very enlightening, which says that the lawyers are officers of the court. They have a duty towards their client, towards the court, as well as to the opponent. So this fairness aspect of a lawyer is not to be discharged as an agent of his client. He is at the end of the day an officer of the court. Therefore, whatever.
In the morning I said
Yes,
no.
yes, yes, yes. This is what, my lord, there's some illuminating, my lord, observations of Sir Ashutosh Mukherjee and a few other judgments. Rajnikant, right.
Rajnikant I have come.
Yes,
We require everything. Let him please.
yes. Now, before that, my lord, your lordship may kindly have a look to these sections only for a second. I don't think I need to deliberate much on this. বইটাকে দিয়ে দাও দুটি জজমেন্ট।
ওখানে হবে। Guardians and what?
আমি দিয়ে দেবো,
Can you provide? Surprised that so you bought 2 sets. Fresh. New
Fresh.
one. That's why that's the old one. Oh, edition is changed, different.
22 edition.
Yes. Okay. Yes, which section?
Well, kindly take me look the definition sections. Section 2A, contempt of court means
Civil and
criminal. Civil is, my lord,
of any order.
order,
That's
etc.
why I said.
Yes. And C is criminal contempt, well, which has got the ingredients expressed in the definition itself, which says criminal contempt means publication, means the publication, whether by words spoken or written, or by signs, or by visible representation, or otherwise, of any matter or doing of any other act whatsoever which, 1. Scandalizes or tends to scandalize, or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. Therefore, my lord, these are the ingredients, my lord, which
I think the Roman one can at best be said to be, because it scandalizes or tends to scandalize, or lowers or tends to lower the authority of the court.
of any court.
Lowers or tends to lower, can the laughing at the court
visible representations, signs.
Because the smile also have a different or of a varied form.
Yes, yes,
Sarcastic smiles,
yes,
as we often receive.
yes.
What?
Milord, these, Milord,
What?
Sir, again, don't lead me to contempt. So, Milord, laughing in order to be a contemptuous act, Milord, in my very respectful submission, should have the effect of a ridicule. Yes. Now, this lowering can be, Milord, in the say in the form of a ridicule to the court. The same may also be in the form of ignoring the court. Say, for example, I say that you don't know the law.
Yes.
No. Therefore, lowering the authority of the court, this again, Milord, is dependent upon the act alleged and the effect of it. Because every laugh, like somebody cracks a joke, I laugh at the court. I laugh. That may, yes, unintended. Yes.
Not tending to lower the authority.
Yes. Now, this lowering of the authority is connected with the act, and at the same time, the same act may not lower the authority of the court every time.
There is a single judge order.
The single judge order.
So I have handed over an original certified.
I'm not getting it here. That's why I'm asking my officer.
Yeah.
আগে যে সার্টিফাইড কপি দিয়েছিলেন কোথায় আছে এটা তো এখানে অ্যানেক্স নেই মেমোর সঙ্গে
এটা একটা লুজ হয়েছে 18 ডিসেম্বর
নো
2023
না না এটা আমাদের অর্ডার বেঞ্চ ইজ কনস্টিটিউটেড
জেরক্স করাও তো আছে
নেই আমার সাথে This is not received.
এক্সট্রা কপি আছে
না দুটো কপি ওটা অর্ডারটা এটা দেখুন তো
এই WPA নাম্বারটা বলো তো প্রসেনজিৎ
2504 CPN 1 of 2023 জলপাইগুড়ি বেঞ্চ
ওইটা জলপাইগুড়ি বেঞ্চে না
Yes, Mr. Advocate.
Yes.
Sorry. We got it. I was just trying to. Yes.
Yes. Then the next section, Miller, in my very humble submission, is section 13. But take an example. Well, these may not, all these sections may not be connected to this case. Since I'm arguing, Milord, let me, Milord, draw your lordship's notice to a few things. Contempt not punishable in certain cases. Notwithstanding anything contained in any law for the time being in force, no court shall impose a sentence under this act for the contempt of court unless it is satisfied that the contempt is of such a nature that it substantially interferes or tends substantially to interfere with the due course of justice. Therefore, my lord, section 13, in my very respectful submission.
Criticism to a judgment also does not come
Yes.
under that section.
Right. So it has to have the effect of a substantial interference. Or in other words, any interference Your lordship, can you have a look to my book?
Anyhow, I can get it. Anyhow. No, it is not here.
But please give me a moment.
It's a topic. The topic. Yes, yes. No, we can share. Don't worry. Mr. Advocate General,
yes,
proceed with the book. Don't worry. 13, yes. Substantially interferes or tends substantially to interfere?
Yes.
Then?
Just give me a moment. Yes, please have a look. But I've got a copy for myself. So, my lord, section 13 provides that, my lord, any and every act of contempt is not punishable unless it substantially interferes or tends substantially to interfere with the course of justice. Then B says the court may permit in any proceedings for contempt of court justification by truth as a valid defense if it is satisfied that it is in the public interest and request for invoking the defense is bona fide. That is an issue of, my lord, satisfaction of the court. Then kindly take, my lord, the power of the High Court now to punish is 14. This is in respect of both Supreme Court and High Court. When it is alleged, this is section 14.
Yes, yes.
When it is alleged or appears to the Supreme Court or the High Court, upon its own view, that a person has been guilty of contempt committed in its presence or hearing, the court may cause such person to be detained in custody and at the same time, before rising of the court on the same day or as early as possible thereafter, shall cause him to be informed in writing of the contempt with which he is charged, afford him an opportunity to make his defense to the charge, after taking such evidence as may be necessary or as may be offered by such person, and after hearing him, proceed either forthwith or after adjournment to determine the matter of the charge and make such order for the punishment or discharge of such person as may be just. Then, notwithstanding anything contained in subsection 1, where the person charged with contempt under that subsection applies, whether orally or in writing, to have the charge against him tried by some judge other than the judge or judges in whose presence or hearing the offence is alleged to have been committed, and the court is of the opinion that it is practicable to do so, and that in the interest of proper administration of justice, the application should be allowed, it shall cause the matter to be placed together with the statement of facts of the case before the Chief Justice for such directions as he may think fit to issue as respect the trial thereof. Notwithstanding anything contained in any other law, in any trial of a person charged with contempt under subsection 1, which is held in pursuance of a direction under subsection 2 by a judge other than the judge or judges in whose presence or hearing offence is alleged to have been committed, it shall not be necessary for the judge or judges in whose presence or hearing the offence is alleged to have been committed to appear as witness, and the statement
Immediately to take in custody is already there.
Yes.
It is vested in it.
Yes.
And thereafter, this has to be followed.
This has to be followed. Now, our case may closely come under 14 because whatever has happened in presence of the court.
Yes.
Then the cognizance part is section 15. Then section 15 is how to take cognizance of a criminal contempt. In the case of a criminal contempt other than the contempt referred to in section 14, the Supreme Court or the High Court may take action on its own motion or on a motion made by the Advocate General, any other person with the consent in writing of the Advocate General, or in relation to the High Court for the Union Territory of Delhi, such law officer, etc. Then the subordinate court contempt is subsection 2, my lord. We can skip over that for the time being. Then section 16, somewhat relevant. Kindly have a look to it. Subject to the provisions of any law for the time being in force, a judge, magistrate, or any other person acting judicially shall also be liable for contempt of his own court or of any other court in the same manner as any other individual is liable, and the provisions of this act shall so far as may be apply according. This is very important. So contempt is not always one-sided.
It is a two-way traffic.
Two-way traffic. Then nothing in this section shall apply to any observation, remarks made by a judge, magistrate, etc. Then, my lord, procedure section 17 I skip over. Then, my lord, section 18 is the one which your lordships were pleased to refer. That a case of criminal contempt shall be heard by a bench of not less than 2 judges.
Now, we have to make a distinction.
Yes.
One is the contempt which comes within the purview of section 14 and a contempt which does not come under the purview of 14.
Yes.
If it does not come under the 14, then in that event, obviously, all these sections are to be adhered to, including section 18.
Yes.
Then the power to put or taken into custody, that is not available.
Not available.
Not available.
You can detain him till the rising of the court.
That is what is section 18, 14 has to be interpreted.
Yes.
Because it says, when it is alleged
Yes.
or appears to the Supreme Court upon its own view that a person has been guilty of contempt committing in its presence or hearing, the court may cause such person to be detained in custody. And at any time before the rising of the court, means to be taken into custody, and at any time before the rising of the court on the same day or as early as possible thereafter, shall then inform that you are in writing and all this follow. So taking into custody is there immediately. But the first word or the words are to be considered where it is alleged
Or appears. So, my lord, the court may also feel
upon its own view
that I may not allege contempt against any person, but the court may feel
of its own view.
On its own view, looking into the conduct of any person. It can be a lawyer, it can be a litigant, it can be anybody else. That there is a contempt committed in the presence of the court, then, my lord, this detention is permissible.
Yes. But he may be immediately released on bond. There is no difficulty. He cannot remain in custody.
Yes. This is, in my humble
He shall be released on bail, bail before the magistrate. Yes. Yes.
So, my lord, this appears to be, my lord, the jurisprudence of contempt, my lord, in our country. That when the court feels that a contempt is committed in its presence, then the court can do this. Now, whether it is contempt or not, again, my lord, it has to go by 2C.
Correct.
2C is not the end of it. There has to be a substantial interference. Any interference and every drop of a hat, if I may put it in this way, is not a criminal contempt. Therefore, my lord, we need to, my lord, now construct our case to ascertain whether there was a requirement of taking action, and the second part is whether the action is contemptuous and in accordance with the act or not. Now, my lord, dear lordship, may kindly, my lord, have a look to the order against which, my lord, the present appeal has been preferred.
We laugh at the time of hearing. That's all. Yes.
This appears to, it appears that, my lord, kindly do not mind my language. It appears that the learned judge or the court had taken umbrage to a facial expression of a counsel. It is nothing more. Now, whether this facial expression has the effect of scandalizing the court or tending to interference with the course of justice, my lord, in my very respectful submission, has to be understood in the context of, kindly permit me to add this, that in the context of, my lord, the proximity of the scandalization, it is not any remote scandalizing or any remote ridicule that can come within the four corners of 2C read with 14, because it says that there has to be a substantial content. Now we need to give some meaning to this expression substantial. Why? Because the court is also to ignore trivial contraventions, possibly. That is why, otherwise, where the expression substantial would lose its significance. But sometimes we speak in Bengali in court. Sometimes we speak, or senior juniors speak quite in a loud manner to the hearing of the court. Sometimes we find the second judge's name, the counsel does not remember, says, yeah, Judge's naam kide? This itself is, according to me, to contemptuous. But whether
Not recognizing the presence of the
another judge. Now, whether this kind of a, which I just give an example, kind to take us.
In order to understand the
Yes. Now, whether these trivial departures, if I may use, are substantially contemptuous or not, are to be looked into. I would very respectfully submitting, Millard, it is a question of fact. Let us assume for argument's sake that the learned counsel had laughed. Let us assume for argument's sake. But I personally feel, Millard, it will not satisfy the ingredients of a substantial contempt, assuming for argument's sake for the present that it is contemptuous. Because the final result must be whether it scandalizes the court, whether it has a tendency to interfere with the course of justice, where the examples of tendency to interfere with the course of justice or direct interference with the course of justice are there. Like in this court, it happened many years back. A litigant threw the sandal at the honorable judge. Yes, in this court. A frustrated man, because of long pendency of litigation, no action was taken. Now, it is, I would be very humbly submitting, it is not the greatness of the judge. It did not satisfy the expression substantial. Therefore,
whether it is a substantial or not, it's more subjective
yes,
than an objective.
yes. And I must concede, again, the satisfaction of the substantial criteria is also a matter of perception.
What I perceive, look at, you have said definitely that member of the bar Suppose if he laughed, let us proceed, whether it was really a substantial contempt which would come. Let us put it more worse. Let us think about it, hypothetical situation. We were not present, we are not omnipresent, nor you were there. I think Mr. Mukherjee is the only person who can tell about it. There was no other persons. Neither of us were there. Let's see. A council who challenged the order of the single bench before the division bench and emerged successful, means his client, not counsel, his client emerged successful. And with a smile, place that order before the judge. Your order is upset. What? Maybe smile, laugh, whatever. Your order is upset. Does it amount to a substantial contempt? Because it is.
So it is the hierarchical system which
There should be
hierarchy.
some restraint. There should be some restraint. There should be some kind of a, I would say, the reservation which the judge or a bench should also command.
Right.
The better administration of
Right,
justice
right,
or to uphold the majesty of the court. Every act, there are many frustrations that grows, that comes. Does not mean because it's unintended.
But at times,
Upset,
yes,
that
yes.
does not mean that
Yes,
you
yes.
are upset the judge.
But I'll give you a Lordship an example. At times, my lord, we advocates, I am speaking of myself, having succeeded in a matter before the division bench, I felt frustrated because the learned single judges order was so well drafted, so research oriented. The learned single judge had himself caused research and delivered a judgment which was upset by the division bench at my instance by a half paragraph order. And I really felt bad that the entire painstaking judgment, research oriented judgment of the Honorable single judge has been, interfered with by the division bench. Therefore, my lord, we as counsels also, it is not that every success brings happiness.
So I take it in a very different way. If the order is assailed before the appellate forum, be it within the high courts or
That's the hierarchy. That's the hierarchy.
it's a view which is being expressed. It is not that the one should get an upset because it's a chance to correct his mistakes, correct his perception, correct his approach to a matter. It's really a learning process. Every day we learn. I always propagate one thing that as a division bench, if the order is interfered with, it does not mean that the order is palpably wrong or illegal. It is what the perception or the looking of the matter or a thing is different from the other. You may look at the thing in a particular manner, the other may look it in a different manner. From a different angle, it changes. So it's all. Even if you look at the triangle from a different vertices or the angles, you will find the different shape.
Right.
So this is how it really, and it's an evolving and a learning process, and one should embrace it. That yes, this is how one should. And there are a lot of changes that comes.
Right.
Perception changes.
My lord,
I must be very candid, really thankful to the court.